Good morning. It is just before midday on Tuesday the 9th of February 2021. My name is Arran Hunt. I'm a partner here at Stace Hammond and I head up the Migration Partners team. As always, this video is not legal advice, don't take it that way. If you're looking for legal advice, then please email us, you can get in contact with us. You can email us at visa@sh-law.co.nz, or there's a link in the description below. Now, there hasn't been much news in the past few weeks in relation to Immigration New Zealand. We don't want to just do videos for the sake of doing a video. I'd rather spend that time working with our clients to get them the result thereafter. But we want to touch on a few quick things today. Now, the first thing is that there were, of course, mid-year changes being planned by Immigration New Zealand for 2021s. They were announced last year. They were announced again at the start of this year. We weren't sure why they announced them again, but they were just announced again. We've seen a number of immigration advisors putting out videos, even in as recently as the last few days, announcing these changes. Of course, these changes were announced some time ago. They are repeating the same information that we were given last year, and which we've covered in previous videos. Now, I'm not going to name the advisors, of course, but just to sort of make you aware that this is old news that is being put out again and again. And in doing so, we think that the announcements just create fear and anxiety for visa holders who look through it going, well, what's new, what's happening, when actually nothing has changed and there's been no new information. So we got some preliminary information last year that was fairly broad and not very well detailed. Now, that information, which we've put in previous videos, we're going to quickly cover a little bit in this video, just so you're sort of aware as to what it was. If you want to see more about it, we've done it in previous videos in the past few months. Now, the main thing here is that Immigration New Zealand is merging 6 work visas into one temporary work visa, and this includes the Essential Skills Work Visa and the Work to Residence Visa, meaning that the Work to Residence Visa would likely sort of be going, at least in its current structure. Now, in place of the Work to Residence Visa, there would be a new residence visa option for those who are earning twice the median wage, which of course is rising $27 per hour in July. So if you're earning twice the median wage, like $54 or so per hour, give or take depending on how many hours you work in the week, you may have a shot at this new visa. Right now we're waiting to see the details. There will also be a requirement for all employers to be accredited before they can employ a work visa holder. Now, accreditation is currently a rather long process. There's a lot of details required, so we are waiting for sort of a simpler accreditation process for those looking to hire just a small number of staff, and there will be 2 levels of accreditation for those who are looking to hire a small number of staff, those looking to hire a lot more staff. But for either way, or at least for the small employer, the old accreditation process as we know it is just too in depth. Would not be sort of necessary for all employers to gain, and so the old accreditation process is going to be going, especially with work to residence visas on the way out. So that is generally what we knew last year. It's what was announced a second time at the end of last year, the start of this year, and it's what some advisors, even the last few days, are pushing out as latest news. It isn't. That's what we've known for a few months now. The one thing that has changed is that nothing has, and I'll explain as to what I mean by that, because that in itself is something probably worth raising. Now, INZ was supposed to provide to us by now the accreditation rules for the employers, so what they're going to have to do before they hire employees come some point this year perhaps, and these were due to us before the end of last year, so there was time there for people to have put something into place. We expect it to take a number of months, so that INZ having given us these rules, it sort of brings into question whether the change will take place in July or not. So that even if the rules came out today, with thousands of companies needing to get accreditation so they can employ staff once the changes occur, we can't see that happening between now and July. They're looking at a new process which nobody's handled before, possibly 10,000 employers need to go through this accreditation process. We can't see that taking place before July. So we're sort of doubtful whether the changes will occur as planned, or at least on the time sort of frame that they're looking at having these done. COVID-19 gives them the sort of perfect excuse to delay it, but to be honest, we can't see why COVID-19 would cause a delay to this internal employment visa process, but we expect that's sort of what they're going to say as to what the delay has been. So what we don't think will change is that the new increase in the median wage, $27 an hour, that will come in July. We're fairly confident about that. So if you are earning less than $27 per hour, but you are on that $25.50 or higher, then you may want to look at applying for a new work visa before the change comes into effect. Now, you don't need to apply now. You could apply closer to that July date. Of course, don't run out of visa in between, because Immigration New Zealand will apply the requirements on you that were in place when you applied, not when it's being processed. So if you were to apply in, say, June, and in July this requirement came through, your requirements will be set at the date you applied in June, so $25.50 rather than $27. So you may want to look at when your current visa applies, sort of expires, whether it's worth applying for that visa now. We were asked in the comments to just mention the difference between a skilled migrant category application and a work to resident visa. Now with work to residence, which we'll call our WRT, these are going at some point, as we said in the previous section regarding the proposed changes mid-year this year. These are going at some point, but we aren't sure of when that's going to take place due to the delays that we're seeing. But people with the options for a WRT will still have that option for at least 6 months, possibly longer, to make use of it. But we're going to do a quick comparison, which will also help for those who are looking for more information about Skilled Migrant Category, which we'll call SMC for short. We've previously done an article about the SMC process, which we'll link to in the description below to give you an idea as to the full process of how you go about applying for an SMC, how it's processed, that sort of thing. Now both SMC and WTR can lead to residence. Now the WTR is a work visa, meaning that it allows you to remain in New Zealand working. The visa itself is for 30 months, but after 24 months you can apply for a residence from work visa, which is a residence visa. And then at that stage you enter into a list for allocation, which we're going to cover in a moment. Now the SMC is not a work visa, meaning that you need to have a work visa at the same time so that you can remain in New Zealand while it is being processed. Now usually this would be an essential skills work visa, though you can apply for an SMC while you hold a work to residence visa, just to give you the best of both options. We have some clients who do that. So we're going to look at the differences now in the two. Now first thing to note is that the SMC process is a two-step process. So first you submit an expression of interest, an EOI, and then normally every 2 weeks the EOIs with 160 points or more get drawn, and if they check OK, they'll be sent an invitation to an apply, an ITA. Now these terms will be familiar to you because they use the same terms with the CPVV, the border exception process, the expression of interest and the invitation to apply. That's where the terms came from. They are used with the SMC process as well. So once you get the ITA, you then have 4 months to submit the actual application. Now at present that draw of the EOIs, it was taking place every 2 weeks, isn't taking place. That stopped when the border closed back in March. It's scheduled to be on pause for a few more months still, after which point it may restart. However, we wouldn't be surprised if the government was to delay that restart further. So at the moment SMC is not an option because you cannot kick off that first stage, that EOI pool. You can submit an EOI into the pool, but they're not doing the draws from the pool, so you won't get the ITA. However, there's no point in us comparing the WTR to the SMC if the SMC isn't an option. So we're going to sort of do a comparison now about what to expect, or the process as it was before the border closed, and an idea of what you can expect once the SMC restarts. It may restart in a few months, or it may be another year away. So this is basically sort of hypothetical as to how things are going to be when it reopens. Of course we are waiting for changes for the SMC process as well, so this could also all change. But for now we're just going to sort of just go through a comparison. So for the SMC, after you get the invitation to apply, the ITA, you then submit the application. Now you send that in, it's all paper-based, it's usually fairly thick if you have a relationship as well. Children, it's very, very thick. You send it off, it's from paper-based, it goes into a queue once it arrives, takes them immigration a couple of weeks to actually get the documents and scan it into their systems. So it'll be about 2 weeks or so before they actually notify you they have received it, so don't panic. And the date that it gets received on is the day that it gets into their office, not the day they get it scanned. So it may not say, it may take 2 weeks to get into their system, but they will stamp it the day it arrives at their office, so they have a date of receipt. So as long as that date is within 4 months, then you've hit that 4-month allowance. Now, if you work in an occupation that requires registration or you are earning at least twice the median salary, then you get priority allocation, meaning that once it's into their systems, within 2 weeks it will be given to an immigration officer to start processing it, which is amazing because if you don't have priority allocation, which most people don't, then it is a long wait. And the same goes for work to residence. Now, while there isn't an EOI process for work to residence, it has the same criteria for priority allocation. If you don't get priority, so you're not in a job that requires registration, so doctor, lawyer, nurse, accountant, anything that requires registration to do the job, then it goes into a long queue, and that queue is the same for both. Now at the moment it's about 19 months of sitting in that queue, followed by another 3 to 6 months of the actual processing the application. And as we covered in a recent video where I went through the numbers, it looks like it is slowing it down even more. So the advantage to an SMC is that you don't need to wait for 2 years to apply. So with the WTR, you get the 30-month work visa. You can then apply at the start of the process, start the residence process after 24 months of working in that, meaning that 2 years plus the 2 years or so of the processing time, it's basically 4 years in total to go from starting the WTR all the way to getting your residence. So SMC is definitely faster, even though that's taking a couple of years in itself. Now the WTR does have some benefits though, and that's why people do still go to that for some situations. First thing is that it's a one-stage process. Well, it's kind of one stage, it's one visa, and then that lets you apply for the second visa. So it's still two-stage, but the first stage gives you a work visa at the same time. There's also the benefit, and this is a major one for some people, is that there is no English level requirements for a work to residence application. So there's no IELTS requirement, no requirement to have studied in New Zealand, all that sort of thing. However, it does require a higher base salary to apply. This changed about a year or so ago, where it was increased up to about $80,000 per year as a base salary. Of course, varying to how many hours you do per year, rather than about 50-odd thousand, which is required for the SMC based on the median salary. So that's a disadvantage for going for the WTR unless you are earning in that higher amount. The other advantage, of course, is that you can apply for a work to residence visa now, and that would give you a work visa for several years before you can apply. But of course, the SMC visa is likely to return within the next 2 years. Fingers crossed, but we're pretty certain it will be within the next 2 years. Meaning you could apply for an SMC visa still before applying for residence under a WTR. So, as it stands, there's not a lot of benefit from going to a work to residence visa unless you can't pass IELTS to a high enough level. And so this would be your only sort of path to residence. Otherwise, for most people, an SMC is a better option. It's a faster option when there are draws taking place. Unless, of course, you don't have enough points for SMC, then work to residence would be an option. It does mean needing to keep work visas going for either option. So if you are on an SMC, you need to have those essential skills work visas ticking over so you can stay in the country lawfully, because if you run out of that visa and you're in the country on an SMC, waiting for an SMC to be processed, then you have to leave the country. Well, actually your SMC wouldn't also get processed. With the WTR, the visa itself is your right to remain in New Zealand, but because it's taking so long to process, you have that 30-month visa. At 24 months you apply, you then have 6 months left over to handle a 2-year application cycle. So you need to apply for another visa after that anyway, so you're going to require further visas. So it generally comes down to, do you have enough points for skilled migrant, and do you have the English requirements for skilled migrant? If you do, then skilled migrant is usually the better option. If you don't, then work residence, if you can get a job with an accredited employer or something that allows you to do a work residence visa application, that could be a better option. But that option is being cut off at some point, perhaps this year. Now, quick message here, we are still getting emails regarding people who are getting scammed for visas. We've done a video, of course, on this, and there's links in that video as to how to check a visa. And remember, of course, that an ESTA is not a visa. If you aren't sure, then feel free to email us a copy of the visa that they've allegedly provided, or they said that they provided to you that's allegedly a real visa, and we can say to you whether it is fake. Most of the times we can just straight away look at it and go, yep, that's definitely a fake. We can say that's definitely a fake. If it is sort of borderline possibly being real, which I haven't seen any yet that I've sort of thought, is it? We can then check with Immigration New Zealand, but in almost every case so far, I've checked the number of these have come through, they've all been fake. And this is obvious, of course, to an immigration lawyer, but to the general public, I can understand how they could come across as being genuine. Now, if you are paying an agent for a job, then it's almost certainly a fake, as the border is only open to those who have exceptional skills or earn a lot of money, or who are a celebrity who the government likes. And as annoying as that is. Now, for everyone else, the border is closed, so employers are not, and never really have, sort of looked for employees from offshore, the only exception being horticulture, where we bring in staff from the Pacific Islands. Otherwise, there is no employer I can ever recall having gone and hired staff from offshore in that way. The other area that might occur is in construction, where typically a foreign company will basically bring across a lot of their staff at once. They won't go looking out for general staff. These will be highly skilled and experienced staff. So it just does not happen. We do not sell visas in this country or jobs. So if you are in doubt, definitely check out that video we've done. There's things on there as to how you can check the visa yourself online. If you don't understand that or you have issue with that, then email us a copy of the visa to visas@shlow.co.nz, and we can come back to you and say whether it definitely is a fake, which so far they all have been. Now, one last thing we want to mention was national security checks. This is raised in our comments, and we want to just sort of quickly touch on this. Now, there's the INZ1200 and the INZ1209 forms. Now, these will often be asked for by Immigration New Zealand for people who are either come from countries with compulsory military service, or countries that are in conflict or near a conflict, or just generally the immigration officer who's handling the application is suspicious of that country. They do cover much the same information. The 1200 covers more topics. It's there to assist the immigration officer by allowing for more information that would not otherwise be asked for in an application. And this can cause a delay if it raises more questions, or they have to go and ask questions from third parties. Now, the INZ1209 is for a national security check. Now, this is where Immigration New Zealand goes to the New Zealand Intelligence Agency, the SIS, to look into you, to just confirm your details, or to make sure that you're who you say you are. The SIS may then go to other international bodies like Interpol to check up on you for any sort of international alerts. Now, INZ will not chase a national security check until 6 months has passed, which delays an application where one is being sought. And we believe that's unreasonable if the NSC is being asked for just because of the country of origin. A 6-month delay because someone was born in a certain country we believe is unreasonable, and frankly it's lazy on the part of Immigration New Zealand. They're going to go, you're born in that country, we're doing a national security check. There should be a basis, we believe, for the request being raised beyond just ethnicity, but beyond just the country that they were born in. We've had actually an NSC that was that caused a long delay, a 6-month delay for a Russian ballerina who had not lived in Russia for decades, but yet Immigration New Zealand still seemed to think that being Russian there was some sort of great risk to New Zealand in granting a ballerina residence. Unfortunately, especially with CPVVs, the Ministry of Immigration is refusing, of course, to even look at applications or to get involved with applications, which doesn't really give many paths other than just waiting for that process to be gone through. It's something that we have raised complaints about, and we know other lawyers that we deal with have raised complaints about it, as we think it's a ridiculous and unreasonable situation as to how it's being used. But unfortunately, there's not much that can be done if Immigration New Zealand want to raise these requests from third parties or offshore parties. They have the discretion to do so, and all we'll do by complaining to them is annoying them. So in most cases it will generally be we can ask them as to why there was a need for it. They won't tell us, and there's not much we can do about it really. So if you're in that situation, if they ask you to fill out one of these forms, fill it out, be complete, all the information you can provide, and hopefully that's enough for them to be satisfied. There's no need to go on to do further checks. If there are further checks required, then be prepared for a delay. Now there has been a lot of media around the government making what we think is dubious decisions about who they do and don't let in, most recently regarding a cruise liner. Now I want to try and avoid talking about these topics, as these are videos hopefully to provide you with information rather than mine just complaining about government process. So we're going to sort of stay away from these issues. If you want to ask our opinion on various points, we'll let you know, but we want to sort of avoid going down that pathway of being just complaining people, and rather focus on things that hopefully you can gain some information or benefit from. And that is it for today. So there's not much happening really. Government does go back to Parliament today. I think Parliament is the first day of sitting for the year. They've taken a nice long holiday, as they do, so we may see Wellington doing some work and making some changes in the next few days. And actually, knowing my luck, when I post this video, something will come out. It's happened a few times, so we'll let you know if anything does take place, if there's any information that you need to know about. Now until then, and today is the 18th annual Safe Internet Day, so we'll put a link in the description to NetSafe and their information about how to stay safer online. So being Safe Internet Day, you've got to say kia kaha and stay safe online.